Good day, ladies and gentlemen, and welcome to the Privacy and Security in the High-Tech Era conference call. At this time, all participants are in a listen-only mode. Later, we will conduct a question-and-answer session, and instructions will follow at that time. If anyone should require assistance during the conference, please press star then 0 on your touch-tone telephone. As a reminder, this conference call is being recorded. I would now like to turn the conference over to your host, Mr. Mike Scarano. You may begin.
Thank you. Hello and welcome to the third installment of Foley's Health Information Technology webinar series. This morning's topic, as you all know, is privacy and security in the high-tech era. We were pretty certain that since we scheduled a webinar for today that HHS would release the final high-tech rule yesterday, but of course that hasn't happened, so we all remain on pins and needles waiting for that. No doubt it'll be released in the middle of everybody's holiday break. Even without the regs, however, there's plenty to talk about in the realm of HIPAA and high-tech, and we have an outstanding panel of 3 speakers to do that. Our invited guest speaker is Ken Mortensen. Ken is Vice President, Assistant General Counsel, and Chief Privacy Officer at CVS Caremark. Prior to that, Ken was the Global Chief Privacy Officer at Boston Scientific Corporation, and before that he served as the Chief Privacy Officer and Civil Liberties Officer for the United States Department of Justice, where he formed the DOJ's Office of Privacy and Civil Liberties. And prior to that, he was the Deputy Chief Privacy Officer at the U.S. Department of Homeland Security. So I'm looking forward to reading Ken's memoirs after he retires because he's really had an incredibly fascinating career, it sounds like. Our first Foley speaker is Jackie Sowie. Jackie is a partner in our Washington, D.C. office. Her practice focuses on HIPAA, managed care, and healthcare antitrust, and Jackie is a key member of our Health Information Technology Privacy Group. Our other Foley speaker, also a key member of that group, is Leanne Habte. Leanne is based in our LA office, and in addition to her law degree, she's a certified information privacy professional, and she devotes a great deal of her practice to HIPAA and other privacy matters, and a lot of that deals with counseling clients on breach notification issues. So with that, I'll turn things over to Jackie.
Thanks very much, Mike. We decided that we would like to begin this session with a summary of enforcement activity that has taken place after the enactment of the HITECH Act as a means of putting Ken's and Leanne's presentations more in context. As many of you who practice in this area know, you can roughly divide HIPAA enforcement activities into 2 time periods: activities before the HITECH Act was enacted and activities after the HITECH Act was enacted. Pre-HITECH, the civil monetary penalties for noncompliance were relatively modest, plus HHS's Office of Civil Rights, who enforces privacy and security, was taking the position that its role was to help covered entities to comply with HIPAA and to take corrective action, and not really to fine covered entities. In enacting HITECH, Congress took exception to OCR's somewhat laid-back approach, and one of the things they did was ratchet up the civil monetary penalties for noncompliance with the administrative simplification provisions of HIPAA. And your first slide is a chart showing or summarizing this multi-tier approach that they took with regard to the imposition of civil monetary penalties. The lowest level is an escalating degree of culpability, but the lowest level of violation is that the covered entity did not know, and by exercising reasonable diligence would not have known that the covered entity had violated a HIPAA provision. And for that lowest level of culpability, which I would argue was not culpability at all, but for that lowest level of culpability, the fine would range between $100 and $50,000 with an annual cap of $1.5 million for all violations of an identical provision. And you will notice from the chart that no matter how culpable you are, there is always a $1.5 million cap for violations of identical provisions in a calendar year. Now, there are some multipliers involved in that. One is that there is the potential for HHS to decide that more than one provision has been violated. So not all the violations are identical. There's also the potential for multi-year violations, in which case it's only an annual cap. So if you violate the provisions in 2 years, presumably it would be a $3 million cap. And then there is also a provision in the interim enforcement rule that states that if the violation is continuing, there's a violation for each day that the violation continues. So in the case of continuing violations, you can see where you might reach the $1.5 million cap fairly rapidly. There are some proposed changes to the civil monetary penalties under the proposed rule, which we are waiting for. A number of them involve clarification that HHS can also impose penalties on business associates as well as covered entities, and that covered entities might be liable for the violations of business associates if the business associate is deemed to be a agent under the federal common law rule of agency, and that HHS could also impose, if you have both covered entities and business associates involved in a violation, HHS could impose civil monetary penalties on both the covered entities and the business associates. So we are expecting, we are expecting some modifications perhaps to the civil monetary penalty provisions after we get the the final rule under HITECH. You would expect that OCR, armed with these new increased civil monetary penalties, would ratchet up their enforcement activity as well, and we have seen some of that. They entered into 3 resolution agreements and what's called corrective action plans, CAPs, in 2011, and we've listed the 3 on the next slide. 2 of them involved hospital systems, UCLA and Massachusetts General Hospital. The last involved Cigna Health of Prince George's County, and I think that most commentaries view the Cigna case as sort of an aberration. Cigna got fined for basically failing to cooperate with the government's investigation. It was the government had received some complaints that Cigna was not giving patients access to their medical records, and basically Cigna just blew the government off. And the amount of the fine basically reflects, I think, OCR's frustrations with the inability to get Cigna to cooperate with the investigation. The other 2 fines are more in line with what we have come to expect, I guess, from OCR. The UCLA case involved employee snooping. Apparently employees were looking at patient records of both celebrity and other co-workers' patient records, and therefore UCLA had to pay a fine of $865,500. The Mass General Hospital actually involved the loss of paper documents on a subway when the employee who had the paper documents was commuting to work. And I think the $1 million fine in that case reflects the fact that the PHI was very sensitive. It included the PHI of 192 patients, and it also included information on HIV and AIDS. So I think that the sensitivity of the PHI really fed the amount of the penalty in that case. There were only 3 resolution agreements in 2011. However, in 2010 there were 2, so we did see somewhat of an uptick in resolution agreements. The 2 in 2010, I thought the first one was interesting. It was the lowest of the fines. It was only $35,000, but it was a fine because the MSO had disclosed PHI to an affiliate of the MSO for marketing purposes. And it was only a 2-year cap. It's only a $35,000 fine, but it will be interesting to see if we have increased activity with respect to sharing information between one covered entity and perhaps an affiliate for marketing purposes. The Rite Aid case in 2010 was again $1 million fine, and that was for not adequately disposing of prescriptions and labeled pill bottles. And that was the case in the CVS CAS, which was entered into in January 2009. And I'd like to pause here and ask Ben, who I think joined CVS after the cap was negotiated, but certainly has been involved in complying with the cap, if he maybe could make a few remarks as to his experience in dealing with OCR in these matters.
Certainly, Jackie, and yes, I joined CVS in November of last year, so the company had already entered into the agreements with both FTC and OCR over the allegations of improper disposal. And I will talk a little bit more in my slides about a process that we are putting in place, but just right here kind of in general in dealing with the Office of Civil Rights, I've actually found that the best approach with the Office of Civil Rights is to make sure that they understand your processes thoroughly and that there is clarity with regard to any of the issues that come up. The example that I might give to everyone there is that we are, as it mentions here, we have a 3-year corrective action plan which requires an independent assessor to go and look at a statistically significant sample of our stores to ensure compliance with the resolution agreement and the corrective action plan. And as part of that, actually, in the past year, there was a visit by our independent assessor to about 770 of our stores, which is about 10%. And on those visits, at a small percentage but a significant number, the Office of Civil Rights actually did send either attorneys or investigators to join the independent assessor. And that means that you need to make sure that you spend the time to work with the Office of Civil Rights in having them understand your operations. Much as a privacy lawyer or privacy professional in an organization, it's critical that you understand those business operations when you are working with the Office of Civil Rights so that they can understand really how it is that you are complying with the law. It's absolutely critical that you can explain to them how the processes interact, be able to explain to them how do your employees know what they know how to do. Obviously, training is a critical component to any one of these corrective action plans that are up here, as well as having them be able to see the culture within the organization. As with any of the regulatory bodies on the federal or even on the state level, the crucial, I would say, kind of feel factor with any of those agencies is if they don't believe that the upper executive leadership has bought into the need to protect privacy and safeguard personally identifiable information, they will look with some skepticism to any of the processes that are in front of them. So I think the crucial part is demonstrating that there's a culture of privacy within the organization. How do you build that culture and ensure that culture exists? And with that, demonstrate to them and explain to them how your business operates. And with that, I have found that OCR can provide us with a fair review and assessment that is actually helpful and not adversary during the corrective action plan itself.
And did you find that OCR put a lot of emphasis on training and retraining during the process?
They certainly have mentioned to me a number of times the criticality of making sure that there was training for our employees, that upon hiring, that folks who are going to become employees of the company have had adequate and appropriate training. In addition, we have spent some time discussing with them the content of that training as well as the delivery of that training. They are right, and I agree with this aspect that any privacy or information security program cannot be successful without a true training and education program that also includes an awareness component. And they will provide actually not just criticism of an assessment type, but they will provide you with a critical eye. And I have found them to be very helpful in discussing when we want to look at some options, presenting to them and getting their thoughts. They've actually been partners in this. It's true you begin in an adversarial situation where the company and OCR are looking at each other, and there's the allegations of wrongdoing and violations and then fines. But in the process itself, the nature of OCR is actually one of trying to ensure that everybody, the patients and the companies, are moving in the right direction. And there have been, my experience has been, they've been extremely helpful in explaining their positions on things and why they would like to have certain things happen and the content that they would like to see, but also being open to you explaining to them why you do certain things, as well as certainly viewpoints on how you would approach things as a company based upon the types of employees and the types of work that they do.
Thank you. I think that's very helpful for people to hear. The OCR has got to be easier to deal with than the prosecutors, and we did want to put a couple of slides in on criminal prosecutions under HIPAA, because we're often asked, does anyone really prosecute anything under HIPAA? By our count, and I can't say this is official, but we have been trying to research this as it goes along. Since 2004, DOJ has brought 38 criminal prosecutions under HIPAA, which, of course, pales by comparison to, say, Medicare fraud and abuse. But there's been 38. 10 were brought in 2009. Only 3 were brought last year, and 9 were brought in 2010. I think, as outside counsel, you're always looking for trends, and although we haven't seen really, an increased activity as far as criminal prosecution is concerned, or an upward trend, I think what is remarkable that of the 38, 32 did result in a conviction by a plea bargain. So although the government maybe has not been in a rush to file criminal prosecutions, they have been remarkably successful once they do file one in obtaining plea bargains. And it's not just for misdemeanors, because of these cases that were disposed by plea bargain, 12 were misdemeanors, but 20 were felonies. There was that one case that's mentioned in this slide that we're looking at now, the U.S. Farrer case, which was actually a conviction by a jury of 87 months sentence. And that case involved basically the defendant purchasing PHI from a cousin who worked for the Cleveland Clinic. And after purchasing the PHI, the defendant submitted false Medicare claims. And I think it is safe to say that if you combine HIPAA violations with Medicare fraud, you're going to be in trouble, and the government will prosecute those cases fairly vigorously. The remaining cases, there have been a couple of acquittals, there have been some voluntary dismissals. Most of the cases have been against persons who have access records for the purpose of some kind of personal gain. Sometimes it's identity theft, or it's, as we discussed, the submission of false Medicare claims. Sometimes it's just been selling PHI, usually concerning a celebrity, to the media. There have been, however, 9 prosecutions that were brought against persons who violated HIPAA but did not have a motive of personal gain. And I think the good news, we've listed the 9 on this slide and the next slide. I think the good news is that all but one, the case was brought as a misdemeanor. There was only one that was brought as a felony, and that particular person, is the second bullet, was actually acquitted after a trial. My own personal favorite is the last bullet, where an employee of a clinic was involved in a dispute with a state agency, and she accessed the psychiatric records. Her clinic was, I guess, treating some of the state employees who were also involved in the dispute. She accessed their psychiatric records, and then she wrote a letter to the government, or the governor, complaining that the state employed people with psychiatric history. And even that one was just a misdemeanor. I thought that might rise to the level of a felony because it did involve psychiatric records. But it was brought as a misdemeanor, and she pled guilty to that one. The next slide should show the remaining, the remaining cases. You'll see on those cases that although brought as misdemeanors, most of those cases involve some kind of improper access to medical records. And usually out of the first two, it was our access to medical records as a result of some, curiosity about a local celebrity or a coworker. And I think that is a risk area that clients are looking at, both for civil monetary penalties as well as for potential criminal prosecutions. Another favorite is the third bullet, where a union president apparently was attending a staff meeting and got angry and grabbed some patient files and refused to relinquish them. I would not have guessed that they would have maybe brought a case against her, but in the end, good sense prevailed and they dismissed that case. So I think you have to be aware that there's the potential for criminal prosecution, but most of the activity, I think it's fair to say, has been on the civil side. And that leads into our next topic, which is, I'm sure you've heard about, the HHS's OCR's new pilot audit program. The HITECH Act requires HHS to conduct periodic audits of covered entities and business associates to ensure HIPAA compliance. And Congress put that provision in the Act because they didn't feel that OCR was doing enough in that regard. And so now OCR has announced that they've established a pilot audit program. And beginning in November of this year, so it's already begun, and concluding by the end of next year, OCR intends to conduct a pilot program of audits of up to 150 covered entities. And it appears that OCR is going to limit the audits at this point to covered entities and not to business associates. They do have a sentence in their announcement saying that business associates will be included in future audits. They said they were going to audit as wide a range of types and sizes of covered entities as possible, and that they basically are using the audit program at this point to determine best practices and corrective actions, but they do reserve the right to bring some kind of compliance review if they determine a serious violation. The next slide summarizes the audit program procedures, and I think what's interesting about those is the short turnaround time for some of the procedures. If you are lucky enough to get an OCR notification letter, they're going to request documents, and you really only have 10 business days to respond. They are going to give covered entities between 30 and 90 days prior to an on-site visit, but the on-site visits could take, they said, as long as 3 to 10 business days, depending on the complexity of the organization, and you will have to set up or schedule interviews of key personnel. And then after the field work is completed, the auditor is going to provide the covered entity with a draft final report. And the covered entity does have an opportunity to comment on that, but the covered entity has to comment within 10 business days, which is a very short turnaround time. And then the auditor is supposed to complete and submit a final report to OCR in 30 business days. As I said, the intent, according to OCR, is to use this audit process at this point to determine corrective actions and to determine best practices, but they do reserve the right to bring a compliance review so that clients should take the audit process seriously, certainly. I skipped over a slide. And finally, I'd like to at least touch on another area of potential penalties and audits. And this time, we're not looking at HITECH Act. We're looking at the Healthcare Reform Act, PACA. I think when PACA was enacted, people did not spend a lot of time or it didn't get a lot of attention. That PACA included a provision that amended the transaction code steps rules. The transaction code step rules, for those of you who are not real familiar with them, are actually enforced by CMS. They are not enforced by the Office of Civil Rights, and as is the privacy rule. And they basically provide that if you're a covered entity and you're communicating to another covered entity with respect to a particular kind of transaction, you have to conduct that, and you're doing it electronically, you have to conduct that electronic transaction in a standard format using standard data elements. And historically, that rule has really been the province of IT staff people. Lawyers rarely got involved in, I think, the transaction code sets rules, but for each transaction, there are currently 9 of them, and they mainly involve claims processing procedures. For each transaction, HHS did issue what was called implementation specifications, which are consist mainly of a manual as to how to implement, what are the data elements and how to implement the data elements and populate the electronic fields. PACA included a provision that basically said that required HHS to adopt operating rules in addition to the implementation specifications for each transaction. Congress said that they thought that the implementation specifications allowed too much flexibility to covered entities, and therefore it undermined the whole intent of the rule, which was to require uniformity in conducting these kinds of transactions. And so now HHS has started to roll out the operating rules, and a covered entity will be required to comply with both the implementation standards and the operating rules for each of the standard transactions, which I think will affect most of our clients, either as a covered entity or as a business associate performing transactions on behalf of a covered entity. HHS issued their first interim final rule under PACA just last July. The interim final rule amended the definition of standard transactions, and there's an amendment, amended the rule or the definition of standard transactions to include that it has to include compliance with the operating rules. It adopted operating rules for 2 of the transactions, transaction to determine eligibility for coverage and a transaction to inquire as to the health claim status transaction. What's particularly interesting is that PACA included penalties for noncompliance. As currently written, those penalties are imposed on the health plan, not other covered entities. But basically those penalties, and in the interest of time I'm skipping over a couple of slides, those penalties provide that beginning in 2014, HHS will assess a penalty against a health plan that fails to meet certain certification requirements. They have to, health plans now will have to certify to HHS that they are in compliance with the implementation standards as well as the operating rules, and will have to provide documentation of compliance. And if they fail to do so, they will be fined, and they're going to be fined an amount of $1 per covered life for each day that the health plan is not in compliance until they can certify that they are in compliance. And if the health plan knowingly provides inaccurate or incomplete information, the penalties are doubled. The penalties are going to be increased on an annual basis by the annual percentage increase in total national health care expenditures as determined by HHS, and there's some statutory caps on future increases, and HHS must establish certain procedures for assessing the penalties and for providing a health plan with reasonable notice and a dispute resolution procedure. So we expect in 2012 additional interim final rules are being issued by HHS under the transaction code set rules, not only with respect to the operating rules that each health plan and each other covered entity will have to comply with, but in addition, with respect to the imposition of certain penalties. PACA also included a requirement that HHS conduct periodic audits to ensure that health plans, and including any entities that provide service to health plans pursuant to a contract, comply with the operating rules as well as the implementation specification rules. So to conclude my section of this presentation, I think we will see a lot of increased activity, a lot of increased rulemaking even after the final rule under the HITECH Act is issued, not only maybe under HITECH, but also under transaction code sets. I think we need to keep an eye on the certification requirement that was built into the PACA transaction code sets rule, because now that health plans are going to have to certify compliance with the rule to CMS. We all know that the government has used the certification requirements to great effect in the area of government contract and fraud and abuse, and it may not have been any coincidence that they decided to use a certification requirement in connection with transaction code sets, because that rule is enforced by CMS. But it will be interesting to see whether the government uses certification requirements in connection with other aspects of HIPAA in the upcoming months. And then I think we can fairly say that 2012 is shaping up to be the year of the audit. And either an audit under the privacy rule, audit under the security rule, perhaps an audit under the HIPAA standard transaction rules. And Ken is here, fortunately, to provide us with some practical tips as to how best position yourself for these audits so that when you get the notification, you don't have to panic. So I'd like to turn it over to Ken.
Jackie, thanks so much. And what I'd like to do is kind of just explain to you at a high level a way to think about putting together a governance process. Before I kind of cover some of the stuff on the slide here, I just would kind of step back and think about privacy in a much bigger perspective. Especially with regard to privacy and security under HIPAA, the basis of that actually comes out of our larger understanding about privacy. And we've seen that larger understanding evolve over the years. For those of you who've been involved in the privacy profession for some time, you probably would recognize the concepts of privacy 1.0, privacy 2.0, and now, especially around some of the things that the FTC is doing with do not track online behavioral advertising and some of the surveillance and geo-monitoring aspects of privacy. We've been talking about privacy 3.0. And those things actually can align to what I would say are three different errors not errors, but eras in the progression of the profession dealing with privacy. And so with privacy 1.0, it was a very straightforward and looking at how do we do compliance. That is, how do we ensure that we are compliant such that we are creating privacy. As we moved to the privacy 2.0 and looked at a broader spectrum of the interaction of data and within the organization itself, we began to need to move to a governance model. And that's what I want to describe today. But I want to put out there for the future something to think about, which is we're now moving, with regard to information, we're moving into a new era overall. And it's not just affecting privacy, it's not just affecting HIPAA, certainly, but as we look at some of these laws, if you look at the PACA, if you look at the requirements under ARA, the push is to put more and more information into digital and electronic format. And this concept of the digitization and the creation of electronic information has changed the perspective of privacy into what we are all calling this privacy 3.0. And organizations need to move beyond a governance aspect and really begin to look at how that organization is placing information within it in all aspects of it. And it's something that we've been calling information superiority, which is ensuring that you have superior use of information such that you have a governance process that optimizes risk within the organization and in connection with information to facilitate decision making. So kind of give a broad perspective on some philosophy behind some of the things that are here. Very quickly, somebody had asked a question about independent assessors and who has to pay for them in regard to that. The entity that is charged with the cap has to pay for those. So although the fines may seem to be not extremely significant, although a few $1 million is not an insignificant amount, it's certainly nowhere along the lines of what we've seen in, say, an OIG corporate integrity agreement type of penalty. However, those fines represent probably on the order of 5 to 10% of the overall cost that will be associated with the response that the organization is going to have to do. So, that would mean something like a $1 million fine is probably means that the company is going to end up spending $10 to $15 million in dealing with that in a response situation, in addition to any other costs that would have been involved with regard to having to seek counsel and go through the negotiation process ahead of getting the corrective action plan. But anyway, as I said, we are progressing from this Privacy 2.0 to Privacy 3.0, but unfortunately many organizations still have not developed yet a manner in which to be able to address things. I note that most organizations today still do not have a holistic program to deal with privacy and security, and certainly how that would impact HIPAA. Although we are, especially as lawyers, many of us are very good at generating out policies and procedures and making sure we're documenting things, there is very many times a disconnect between those policies and procedures and the actual practices, the technical implementation and procedural safeguards that are being put in place within an organization. And then, as Jackie noted, this has caused an increase in the number of enforcement actions that we've seen, and certainly what types of things that the OCR has been looking at. And obviously we have audits that are upcoming. I would also note, sitting in the position of both a covered entity and a business associate, depending upon which part of the business that you talk about for CVS Caremark, audits aren't just coming from the federal government, although OCR is the agency charged with ensuring the enforcement of HIPAA. You can get audits from clients. So if you're a business associate, you should be expecting that your covered entity clients are now going to begin auditing you a lot closer because they're going to be worried about their own compliance, including that which is progressed through you. So how do you deal with creating a holistic program? And as I said, I prefer to take what I call a governance approach to that, and there's three main components. The first component is policy. Obviously, we need to have policy as part of that. The next component is assessment. You have to take that policy and assess it against your practices and procedures. Then once you discover what those gaps, you do treatment. I'd like to use the word treatment and not remediation because I'd like to say that we are progressing forward. If you say remediation, it assumes perhaps that where you had gaps may have caused risk specifically. So I think it's more important to talk about it in a treatment sense because we're talking about taking it to the next level. And then once you've done that, you need to do monitoring. That is, you need to assure that you have a continuous process. So the next thing to do is after you go through all this process, go back in the monitoring and say, okay, what, do we need any new policy? Do we need changes policy? Do we need any type of reassessment? And again, it's a continuous process that would continue through the life cycle of dealing with this. So in policy, what are some key aspects? Obviously, I mentioned that most organizations have gotten pretty good. There's a lot of stuff out there. If you just Google HIPAA privacy policy, there's actually a number of really good sites out there where you can steal all of their stuff right off of what they have and kind of work from that. And a lot of the templates in that sense. But again, you got to think about policy not just in its standalone document format, but how does it actually connect to the rest of the organization? And HIPAA in itself should not be a standalone. I think that's one of the mistakes that many organizations make, that even if they are a healthcare organization or a healthcare provider, that they tend to look at the HIPAA as a separate and distinct area, and that's a compliance approach. A governance approach says that it is but one component and will help govern the way that we are looking at privacy and security overall within an organization. Also, I would say that there tends to be sometimes an opposite where people will have their own privacy and security policies that they've put in place for other purposes. This would be in organizations that perhaps are not necessarily focused in the healthcare industry, but do have a healthcare component, like a hybrid organization or one that may be part of an affiliated group, and they would not have a HIPAA structure within their policies, rather than be structured under some other approach. I still think, though, that notwithstanding what I just said about not letting the HIPAA tail wag the dog, you still want to align the policies along the lines of what is available within the HIPAA structure itself in terms of the privacy and security rule, in terms of enforcement and breach notification. The other thing that's important with policy is that you need to make sure that the policy recognizes the life cycle of information. You need to be able to understand how is information generated, created, stored, used, and accessed, and then finally destroyed and erased. That is very important that be put into the entirety of how you put your policy together, because, again, although HIPAA and the privacy and security rules focus on particular activities and uses and disclosures, for an organization, it is the life cycle of that information which is critical to understanding how do you connect policy to implementation. The next stage would be to do an assessment. Some typical things. You're going to do risk analysis, risk assessment, you're going to do impact analysis. And I think here's the critical part. You need to link both HIPAA and business requirements. There is more than one way to skin a cat, they say. That is the same thing is true, which is there is not just one way to be able to handle the implementation of a particular safeguard under the security rule or a particular protection one will find under the privacy rule. So you need to make sure that the privacy aspect or the security aspect is not going to prevent facilitation within an operational setting. Other thing with assessments is you need to do prioritization. And one of the key things here is you want to be able to deconflict business and compliance needs. You want to be able to understand how do you have to address things. There may be certain business opportunities that are necessary to move forward that you not necessarily are going to say, well, we won't worry about privacy in that situation, but we need to be able to optimize the risk. That is, make sure that we can drive to a successful business conclusion to keep the organization moving forward, while at the same time figuring out what's the best way to create a situation that is not increasing and, in fact, is decreasing the risk to that. And to do that, you need to define what are your objectives and targets for the program overall and how are those linked to the goals of the organization. So the third step is treatment. Once you have done your assessment, you will have gaps. And I say that in that manner because you will always have gaps, even if you have an extremely comprehensive program. In any situation, you will always have something new that will appear that you will be able to define as a gap within that particular assessment. We need to be able to make sure we're addressing those things. So I say for privacy, we want to look at things and make sure we're, connecting things that are in the line of how do we describe what is minimum necessary? What are we talking about that is treatment, payment, healthcare operations? Being able to connect those together in terms of what we've seen in the gaps. For the security, link whatever control sets that you have picked for security with how you do the implementation of administrative, technical, and physical measures underneath the rule itself. Very important, and this a step that many privacy professionals do skip, is defining what is the business process itself. Make sure you understand what the data flows are, but not only the data flows, but what is the objective that we're getting to within that process. Why do we do the things that we do? Sometimes what that can drive is a discussion about an alternative business solution that gets to the same ends, but we use different means that can employ better security and privacy. And then also make sure that you're associating the implementation process with other processes that exist as well within the organization, such as awareness and training and incident management. Then the last step, again, I mentioned, was the monitoring step. And essentially, this is the part where you're going to make sure that you've captured everything into the cycle, that you have looked at what is going on, and then you continue that process to go back and do the policy, the assessment, and the treatment. There are a whole bunch of different ways to the three main ways, or if you would kind of pull out the different flavors of being able to do some sort of monitoring. Broken out here, I call one a task force. This is a dedicated team that's going to go in there, they're going to drive and look at particular things. For example, here at CVS Caremark, we have what we call a vendor assessment program. I have a team of folks that reports to me that specifically goes and looks at privacy and security controls with regard to the vendors that we have that handle personally identifiable information, including PHI. That is focused specifically on monitoring those vendors that work and then therefore within our cycle of governance driving that too. Another matter is to use what we call project management, that is to look overall into IT projects. Within the government, when I was there, we did what we call privacy impact assessments. Sometimes in the business, we call them business impact assessments that would incorporate privacy and security assessments and analysis. And then the last part is self-assessment. And that's where we go and we look at an entire business process, and as an organization, we have that organization, the business, participate in that particular process to be able to assess where they have the gaps and to be able to kind of use that ongoing assessment as the monitoring tool that then allows us to determine, do we need to do additional policy or change the policy? Do we need to assess other different aspects? And how do we treat those things once we discover what those are? So in a very quick way, that helps bring us to a discussion now about some of the additional requirements that we're seeing from the HITECH Act. So this is a process, if you will. The governance allows us to be able to understand within the organization how to move things from the current state to a future state. And now Leanne will discuss how do we understand what are some of those requirements that exist within the HITECH Act. Leanne?
Thank you. Yeah, so we have, a number of challenges in compliance with HIPAA under the current requirements. And, of course, in the future, we expect to see additional challenges arising. Some of the key areas where the HITECH Act, as you know, has imposed new requirements on organizations are with respect to breach notification, which we're all quite familiar with. The HITECH Act, of course, was intended to impose the restrictions on use and disclosure of PHI on downstream entities, including business associates, a variety of data transmission services, personal health record vendors, and other members of the workforce that would handle PHI within the organization, such as volunteers and trainees. In addition, HITECH proposes to increase the restrictions on marketing and fundraising, prohibit the sale of PHI, and add additional restrictions with respect to minimum necessary requirements. Other types of changes we have seen as a result of the HITECH Act have been an expansion of individual rights, particularly in regards to access to and accounting of electronic health records, and we are looking for additional guidance on that. Under the proposed rules on accounting for disclosures, HHS proposed to create an even more expansive requirement to allow individuals to access information in electronic records, designated record sets in electronic formats, and to account for disclosures of information of PHI in electronic format, even if it was not in an electronic health record. We've also seen additional requirements being imposed with respect to notice of privacy practices. The one area where I think the HITECH Act liberalized the requirements in some respect is in the areas of research. And the proposed rules, of course, included the option to have a compound authorization for research and other uses and disclosures of PHI, and also contemplated that that an authorization could address current and future research uses. Perhaps. We'll see what comes out in that regard. So as Mike and others have talked about, although there's been a lot of interim guidance and proposed rules on these issues, the final rule is still pending. So that will be a very important issue for us to look to. With respect to the breach notification program, that has been around now. We have had interim final rules for about a year and a half on that. And recently, the Office of Civil Rights issued a report to the Congress documenting basically what the progress of that program had been. And I think it's interesting because we can see that there were approximately 207 reports in 2010 and 45 reports in 2009 with respect to breaches involving more than 500 individuals. When you look at the common causes of those breaches, they're really, a small number of key categories. And three of the categories, theft, loss of electronic media or paper records containing PHI, and improper disposal, have something to do with the actual physical security for PHI. So this, I think, provides organizations with fodder for some thought about issues to address within their compliance program. In terms of smaller breaches, breaches of less than 500 persons, primarily the causes were misdirected communications, which is just an ongoing issue. When we look at how organizations responded to these breaches, of course, we see a lot of modifications with respect to administrative procedures, including policies and procedures, training and retraining workforce members and imposing sanctions, and revising their business associate agreements. We see changes in the physical security and some changes in the technical security for PHI. So, in addition to the breach notification requirements, as I mentioned, I think one of the significant implications of the HITECH Act is with respect to the relationship between covered entities and third parties. I think there are a lot of direct and indirect implications of the HITECH Act in these areas. So when you look at relationships with business associates, before the HITECH Act, it was a pretty simple world. The requirements for the business associate agreements were defined in regulation. Business associates were not directly subject to HIPAA. They were subject only to their contractual liability with the covered entity. And as Jackie had talked about, even where there was an agency relationship between a covered entity and a business associate, there were exceptions from liability in the rules if a compliant business associate agreement was in place and the covered entity was not aware of a pattern or practice of violating such agreement. So on both sides, there were some limitations on liability. Under the new framework, we have, I think, increased liability for both parties. First of all, business associates are directly liable under the HITECH Act for violations, even if there is no business associate agreement in existence between the parties. The definition of business associates is proposed to include not only those organizations that contract directly with the covered entity, but also the subcontractors of business associates. So a number of organizations that are not healthcare organizations and previously haven't been governed by HIPAA will now be subject to this law. As was mentioned earlier in this call, under the current and proposed rules, liability can be imputed to the covered entity for violations by business associates if an agency relationship exists, and a similar imputation of liability exists for subcontractors and business associates. The express exception to vicarious liability for violations of agents is proposed to be removed from the federal regulations. So in terms of what some of the key requirements for business associates, as you have become familiar with, I'm sure, in addition to making business associates directly subject to some of the privacy requirements under the HITECH Act, the big issue, the most significant issue, I think, is that business associates are now directly subject to the HIPAA security rule. So they're required to implement administrative, physical, and technical safeguards in compliance with the HIPAA security standards and to meet the policy and documentation requirements. So where in the past a business associate may only have had to provide reasonable and appropriate safeguards, now they have to go through the whole process of conducting a risk assessment, addressing the specific implementation standards for security under HIPAA, and having written policies and procedures that are HIPAA compliant for documentation. So this has implications, I think, for the relationships between business associates and covered entities, because covered entities will feel the need to ensure that their business associates, in fact, have such procedures and policies in place, and business associates will be faced with the challenge of developing such policies and procedures. Under the HITECH Act itself and the proposed rule, there are certain additional requirements that must be incorporated in business associate agreements going forward, including compliance with the security rule, a requirement to report breaches of unsecured PHI to covered entities, and a requirement for business associates to ensure that their subcontractors that create or receive PHI agree to the same restrictions and conditions that apply to the business associate with respect to such PHI. So I think one of the results of that, these changes, is that there is more liability associated with the business associate agreements and the business associate relationship. There are, for example, the costs and expenses associated with breach notification that need to be addressed, and mitigation of harm, such as credit monitoring services. There is the issue of which organization is responsible for determining whether reportable breach exists, and for notifying the individuals. There's the issue of whether business associate agreements should include any limits on liability if, for example, there are such limits in the underlying service agreement. Issues related to whether an agency relationship exists between the parties. And then there are a variety of other damages that have implications for liability. In addition to liability under HIPAA, arising from, for example, civil actions brought by state attorney generals and or any investigations associated with HIPAA, what I'm seeing is that organizations are also trying to build in compliance with state privacy law requirements into their business associate agreements. And under state privacy law, in many cases, there are also breach notification requirements, and in many states, individuals can bring action against a covered entity or other organization. So again, we have a much broader framework for liability in the new environment. So I'd like to just stop and kind of get Ken's input on this particular issue. And Ken, in considering the implications of the HITECH Act for relationships between business associates and covered entities, do you have any comments or insights on how you see these changes impacting the relationship between these parties?
I would certainly say that in both aspects, because we serve both as a business associate and as a covered entity and that has business associates, the relationship certainly has changed, where at one point it was obviously connected, but it was connected more in the traditional subcontractor way. With the changes in HITECH and the both, I would say, two aspects of HITECH really have impacted. One is the now, if you will, the direct liability of business associates under the law, as well as the data breach notification rule, have created a situation in which covered entities are asserting more control, if you will, over the contract, certainly over the business associate agreements. Aside from the technical aspect of, over the last couple of years, you have seen everybody going and rewriting their business associate agreements to incorporate things like the breach notification rule. Certainly what it has done is change the risk posture, where before the covered entity under the law was solely responsible. Now, even though we do not have final rules on this, certainly within the statute itself, it seems to be quite clear that a business associate would have at least some level of liability, and certainly liability exists for their own wrongdoing of acts or omissions. So I think that in terms of both being a business associate, you have to recognize that and be prepared to deal with that. And as a covered entity, you certainly should be able to exert that aspect of leverage within the relationship to ensure you have those sorts of protections. I think that any company or covered entity that fails to ensure that they have complete assurances from their business associate with regard to the policies and procedures to comply with HIPAA and fail to have a full unlimited indemnification for third-party claims under a breach or security incident and have unlimited direct damage liability for the cost of responding to, notifying, and remediating such events would be foolish in this day and age. Certainly the changes that have been there. So on a business associate side, we've certainly seen where we have been in situations where, those things are being foisted upon us, and I certainly will foist that upon our vendors and business associates because there is that risk that exists, and the business associates are, as I said, they're more connected to HIPAA than perhaps previous to the changes in HITECH.
Thank you. I think that's a great insight, and I just want to mention before getting off this particular subject that right now there's some ambiguity also regarding compliance with these changes. The HITECH changes related to business associates were effective on February 1st of 2010. The proposed rule extended the compliance date and provided particular extensions for business associate agreements. However, the final rule is still pending. So there is no direct authority, legal authority now for extension of that compliance date. So there's a little bit of ambiguity under the current situation. I'm just going to touch briefly, given the time here, on an additional area where we have seen changes under the HITECH Act with respect to relationships that impact a covered entity and a third party. And those are in the areas of marketing and fundraising. Now, the previous HIPAA framework for marketing required, of course, authorization to use or disclose PHI for marketing and defined marketing to include both a communication about a product or service that encourages recipients to purchase that product or service and an arrangement where the covered entity disclosed PHI. There were certain exceptions for face-to-face communications, et cetera, and promotional gifts, which continue under the HITECH Act. However, pre-HITECH, there were certain exceptions that applied even if some type of indirect or direct payment was involved. One of those areas was for healthcare operations communications, which allowed an entity to describe a health-related product or service provided by or included in a plan of benefits, or health-related products or services that added value for the enrollee. Now, CMS had interpreted these requirements to, or provided guidance that such exceptions would also apply to healthcare providers and not only to health plans. There were also exceptions for communications for case management or treatment of the individual. What we see under the HITECH Act is a broad restriction or tightening of the requirements when there is remuneration involved. So under the HITECH Act, there are limits imposed on the cross-promoting of products or services of third parties without an individual's authorization. Although certain healthcare operations communications continue to be accepted, that's only the case if no financial remuneration is involved. Treatment communications are still allowed if financial remuneration is received. However, individuals have to have the opportunity to opt out, and there are additional requirements with respect to the notice of privacy practices. There are still some exceptions to the definition description of marketing that apply, even where there is some type of indirect or direct payment involved, and one area is where communications are for the purposes of describing a drug or biologic that had previously been prescribed or administered, provided the amount of the remuneration is reasonable, and the final rule may provide further guidance on this particular issue. In addition, the HITECH Act has separated kind of marketing from the sale of PHI, which involves the disclosure of PHI to another party, a third party, and requires a statement that on the individual authorization to note that such disclosure will result in financial remuneration. So there's a lot of emphasis on informing the individual and disclosing if any type of payment is exchanged between the parties. These same type of requirements, in essence, are applied to fundraising. So individuals, likewise, have a right to opt out of fundraising communications. There must be a clear and conspicuous opportunity to opt out of communications. The notice of privacy practices must include information about fundraising communications, and organizations are really required to abide by the opt-out requirements. So if an individual has opted out, they have to be very careful not to send future information to such individual. So again, I'd like to ask Ken to weigh in here. And given these changes, do you have what is your perspective on any challenges that compliance with the marketing or fundraising provisions might entail?
So I think the challenges for some organizations will be in trying to understand what it is that one can do with this information that is the line between what is actually marketing and what is informing the patients about the services that the organization had. And I think that that's something that we are still waiting for the rule from HHS, and that would be the most helpful thing to see at this point, because there is still this gray area. So until the rule comes out, I think most people are going to be very careful about this. Certainly it's clear that if you exchange PHI and you get money for it and it's to a third party who then does anything with it that promotes their business or products, that's clearly going to be marketing. But other situations where a healthcare provider perhaps sends out a card letting folks know that they've just installed an MRI machine in the offices now, is that actually going to get new business from the patients, or is that just informing them of a new existing service, a service that is new but under their existing availability with that healthcare provider?
Yes. So as Ken had mentioned, we are looking forward to the final rules to provide some additional definition on a number of these issues related to exceptions to sales of PHI, the scope of the opt-out requirements, the amount of allowable communication, how fundraising campaigns can take place under these new rules, and exactly how a subcontractor of a business associate may in fact be defined. So certainly we can expect to see future changes, and on that note, I am going to turn this presentation back over to Mike to take any questions you may have.
Thank you. If you have questions, there's two ways that you can pose them. You have a live phone and you can just ask them over the phone, or on your screen you've got a tab which will permit you to type in a question. And so,
Mike, this is Ken. There's one question that is posted there that I think may be directed to me, and the question, I'll read it for everybody just to make sure. It says, do you require business associates with access to PHI to have breach insurance coverage with you as an additional insured? As a covered entity, or even as a business associate with a sub-business associate, yes, that's something I really would like to have. But to be honest, that's not always possible. Certainly with larger organizations and something that would be a national organization, and the IBMs, Microsofts, Deloitte & Touche, those organizations in the world. That's something that's pretty straightforward and standard, and the usual insurance language that we would have in our master service or professional services agreements would apply there. But we also, in many situations, given the uniqueness of some of the products and services that we offer, work with much smaller vendors who may not have the capacity to be able to get the coverage at the limits that might be necessary. So some of this also entails understanding what that risk is, understanding how you might want to address that risk if you cannot have that insurance there. Certainly, we would look to the vendor, as I said, to indemnify us and to provide liability protection for the direct damages. But even then, some of these vendors are very small. Some of the, if you will, the costs associated with the products or services are not great. You can have something that maybe it's a project that's only going to cost $250,000, yet if you have 5 million individuals' information that will be exchanged as part of that particular project, certainly if all that information was lost, multiply that, by say $10 just for the basic costs associated with the notification and providing of the services to the individuals, you're already, well beyond the actual cost of the contract itself. So one thing I also would recommend is that as a covered entry or as a business associate who subcontracts out, you need to make sure that you understand what your risk profile is with regard to your own privacy and security liability insurance and understand what those limits are for yourselves.
Great. We have another question. I'll just open this up to the panel. Is it likely that a covered entity that reports to HHS a breach involving less than 500 individuals, that the covered entity will be investigated by HHS?
I'll take a shot at this one. I'm going to say, I think we're going to have to wait and see. You might think that they were going to go after the really big ones, but I would say that those organizations with the very large breaches probably just in and of themselves will be investigated in any case. I mean, anytime there's a breach greater than 500, the HHS OCR will be looking into those anyway. So you might think that they're going to look at the types of breaches that are there and how do they occur. I think it's quite possible that in doing the audits to understand the nature of the information flows and the types of breaches that could occur, HHS might look at some small ones just because of the simplicity, and therefore I think you might look at things like small healthcare providers like doctors' offices and whatnot that would be the subject of some of the audits.
Okay. We've got another good question. Can you discuss the accounting of disclosure and what the government's thoughts are related to the difficulty placed on providers?
That's a question I would love to get the answer to from my friends at HHS. Everyone's been mum about that particular one. I don't know that anyone really has heard anything yet. That's a tricky one. You probably have all seen, if you've paid anywhere attention to this, there's been a lot of commentary out there about the difficulties that the current version of the proposed rule would place upon covered entities, and certainly would also in extension to business associates. So I think this is yet one of those things where we need to wait to see how the department responds to the commentary. I think the commentary is very clear that perhaps the burden that was being placed to implement what the rule was far, far greater than any benefit that might be there. But again, we will have to wait to see what happens.
A participant by the name of Barbara liked the idea of the vendor task force to monitor their compliance with the security requirements. However, as an organization with limited resources, I would like some additional guidance on how you can accomplish this. Also, if you are not monitoring their compliance, will the covered entity be held accountable?
So, Mike, I'll jump in here. I'll answer the last question first, and that is yes, the covered entity is always liable with regard to the activities, and one of the things that you need to do as a covered entity is ensure that those who are handling PHI on your behalf are doing so consistent with the rules. If you are not a large enough organization to have a whole staff to be able to do this for you, there are some alternatives. You can create more lightweight programs, and also you could focus on vendors that are ones that are going to be critical. So again, it's not every single vendor you would have to do, but you can focus on those, say, that are handling PHI. What I would recommend you do is there's a program out there called Shared Assessments. Now, this was created out of the BITS program, which was a security group and special interest group out of the the Financial Services Roundtable. Even though some of the stuff that came out of there was originally focused more on the financial industry, they have over the last few years taken on a number of the different aspects of healthcare, including linking their particular questionnaires that they have and the program that they have, the templates for on HIPAA. So I would suggest you go and check out their website. I forget what it is, but certainly if you Google shared assessments, that will come up.
Julie asks, is there a reason for a covered entity to have several separate policies covering all aspects of HIPAA instead of combining all requirements into one large policy?
I can answer from our perspective. My preference, and I would just say it's a preference, is that it allows me to be able to manage those policies a lot easier than if it is all in one policy. If you think about it, what you may be asking is, can it all be in one document, or is it all one policy? I would say that a security policy and a privacy policy, even if they are in a single document, still represent separate policies because they go to different means. Privacy policy protects privacy, where security policy will be implementing safeguards with regard to the administrative, technical, and physical safeguards. So, again, some of it is just your preference and how you approach this. Smaller organizations many times will have a single document in which they will place all of these in there. Whether you call that a single policy or you call that multiple policies, it doesn't really matter. I think the key, though, is that I want you to take away from my discussion of policy was that you have addressed each element of the rules and what's in the rules in a distinct manner.
Jerry asks, in your opinion, how likely is it that a hybrid covered entity will be included in the initial compliance audits?
I actually throw that out to my fellow speakers. That's a good question. I'm not sure.
I think we can only guess.
Oh, I like the next question, Mike. I want to confirm that an individual can be held personally liable, civilly and criminally for violations under HIPAA. And I would say definitely yes. This is what I call my orange jumpsuit line. When I go in and I talk to other business executives and leaders of my company, I remind them that there are 3 folks within the company that have personal liabilities for the failures of the company. The first is our Chief Financial Officer under Sarbanes-Oxley, who gets to go to jail if we decide not to report something material from a security standpoint. The second is our Chief Compliance Officer, who under our Corporate Integrity Agreement likewise gets to go to jail. And then I do under not just the HIPAA laws, but under other privacy laws as well. There is typically somewhere criminal liability for the officer in charge of the implementation of an information security and privacy program. And for those of you who might kind of doubt that, since there really hasn't been anything in the States, there was an international case where the privacy officer for Google over in Europe was actually convicted and for a privacy violation in Italy. So this is not anything that I wish to test out at this time.
I've got a couple of questions. One question is, can any of you tell us about the State Attorney General's enforcement authority and what that means for covered entities and business associates?
This is Jackie. The HITECH Act did not create a personal private cause of action, which some people feared it would, but it did authorize the Attorney General of each state to conduct HIPAA compliance reviews and to bring suit in order to enforce HIPAA. And there is a provision, or there is a notice that HHS recently issued, saying that OCR is actually conducting HIPAA compliance training for the attorney generals, so that they can go forth and do their audits and bring their suits. So we do expect to see an increased activity on the behalf of or by state attorney generals to enforce the HIPAA requirements in the future. And we've already seen some activity in Connecticut and California, but we think that other states will follow suit.
Great. Does anyone else have any other questions?
Mike, there was another question online. Basically, it was kind of saying, what about, is there any way that under kind of the agency law, is there a situation you could think of where business associates' actions would not be imputed to a covered entity? And certainly, I think the answer is yes, because under agency law, the subcontractor is only the agent of the principal insofar as it's within the scope of the activities that have been authorized. If a business associate, say, would take information that would be provided for the particular business associate functions and then use it for something else, those would not be within the scope of the agency that was created. Therefore, while there may be some liability on the part of the covered entity with regard to their potential negligence in the selection or oversight of the business associate, that doesn't necessarily mean that all of the liability for the actions would fall upon the covered entity. Indeed, if the covered entity could show that they had done all reasonable measures and had in good faith monitored the business associate and the business associate had gone on and done this on their own, I think that it quite clearly would fall solely upon the business associate themselves.
Any other questions? Let's see, I think there's one more. Do you require BAs with access to PHI to have breach? Okay, we've already answered that one. I think that brings us to the end of our program if no one has any other questions. I'd ask you all to please fill out your evaluation forms, which will appear on your screen shortly. And we appreciate your attention and participation. A lot of good questions this morning. Thank you.
And would you like to take questions over the phone at this time?
If there are any questions, I think we've fielded all the questions over the internet here.
Okay. In case, ladies and gentlemen, if you have a question, please press the star, then the number 1 key on your touch-tone telephone. And I'm not showing any questions. Ladies and gentlemen, thank you for participating in today's conference. This concludes the program. You may now disconnect. Good day.